Hello, welcome everybody. It's so nice to see all of these faces here today. Thank you for joining us on your Sunday afternoon. This is a huge honor for me and a huge privilege to be introducing Judge Dorothy Nelson. As many may or may not know, I'm an attorney as well and look up to you very much, hold you in very high esteem. And it's really, truly a pleasure for me to be here today introducing her. This has been something that's been in the works for quite a while and something that I've been anxiously awaiting. I know dates have been changing and I've just continuously been looking at the calendar like, okay, when is she going to come? When is she going to come? So it's great to have her here. So for those of you who may not know her very well, though she's going to make an attempt, is exactly right, to introduce her. It's a very long and very impressive biography here, but I'll try to give you the highlights. She is currently, Judge Dorothy Nelson currently serves as a federal judge at the U.S. District Court of Appeals for the 9th District. And she was nominated there by Judge Jimmy Carter back in 1979. She has said in herself that when she decided to go into law because she wanted to stand up for others. And as a teenager in Los Angeles, she led a club for underprivileged kids and saw the effect of the courts on their lives and decided, I'm going to be a lawyer. They seem to have the power to make things better. So Judge Nelson said that she decided to choose a profession where she would be able to serve other people. And a lawyer has the training and the skills to bring about real change in society and to assist others. And indeed, she did bring about that change. She earned her law degree from UCLA, my alma mater, go Bruins, and went on to receive her Master of Law degree from USC in 1956. The following year, she joined the school's faculty as USC's first female law professor and continued to rock the boat and raise eyebrows during her first year at USC, as she started inserting materials on mediation, which at that time I'm sure was unheard of and very new. She set out to raise the bar at USC and help establish the Dispute Resolution Center, being the first dispute resolution center at a law school anywhere in the country. Dorothy Nelson became a Bahai after graduating from law school and went on to a distinguished career of service in law and to the Bahai faith. After being the first female law professor at USC, she then went on to be the first female dean at USC, which again was the first dean at any major U.S. law school. In 1969, she was elected to the National Spiritual Assembly of the Baha'is of the United States, which is the body that guides national Baha'i activities. And since then, she was re-elected annually until her retirement in early 2009. She, like I said, she currently serves as a federal judge and has helped found the Western Justice Center, along with receiving many awards in law, the last of which I attended a luncheon from the Los Angeles County Bar Association, where she was honored as the Outstanding Jurist of the Year, which was quite an honor. As a woman in law, I consider her truly a trailblazer for all of us, paving the way for opportunities for women across the world in the legal profession. And it is a great privilege and honor for me to introduce and welcome the Honorable Judge Dorothy Nelson. Thank you.
Thank you so much for that lovely introduction. I can't tell you what a pleasure it is to be in this beautiful Baha'i Center. I live way across the town in Pasadena, but it's always a joy to walk into this place. It's bright and light. Everybody is friendly. Everybody is interested in everybody else. And I thank you so much, Payam, for inviting me here. I see in the audience some former students, a Superior Court judge, Well, just a whole variety of people who not only do not live here, but came quite a way to participate today. And so I hope that in the discussion groups, you will take advantage of these very wonderful, outstanding people. And I'd like to sit in and listen to what they're talking about. Well, when I was a student at UCLA, in the law school in the early 50s, I was sort of angry about the cases that we read, because I often found that a just solution was not found. And Dean Roscoe Pound, the former dean of the Harvard Law School, said, "Good, you should feel disturbed, because we do not find that justice is achieved throughout the country through our court system." He said it didn't matter what the law was. What mattered was the process that we used to bring about justice. Well, it was just about this time that I was introduced to the Bahai faith by a fellow law student. It was an unusual introduction because 72 members, we were the second law class at UCLA, were invited to join a fraternity, a legal fraternity. There were only 2 women in the class and 1 black. We all joined, and guess what? 6 weeks later, the National wrote from Chicago, "Sorry, no women, no blacks." This student called us all together. Honestly, he had been quite a political figure in undergraduate school, and I didn't think he had a serious thought in his head. Nonetheless, he said, "Let's all resign. This is not right." All 72 resigned, and they formed the UCLA Law Association. And we women and our 1 black friend were invited to join. And I walked up to him and said, "Whatever led you to do this, Donald?" And he said, "I'm a Bahai, and we believe in," no, he said, "I've been studying the Bahai faith. We believe in the equality of women and men and the abolition of racism." He said, "Would you like to come to a Bahai fireside?" I said, "Oh, no, thank you, Donald. I'm very active in my own church," but it was a very nice thing to do. Well, after he sneakily had us to a steak dinner, and we were going to play bridge, and just as he passed out the cards, he said, "Say, would you like to go to a Bahai fireside?" My husband raised his eyebrows, and I looked at him. We were obviously free for the evening, and after living on hot dogs and macaroni and cheese, we just had a steak dinner. So we went. Well, needless to say, it affected our lives. Donald was our first to become a Bahai in my law school class, but interestingly enough, in the next 10 years, 17 members of the class, including their families, became Baha'is because of that one righteous act. Well, one of the things that fascinated me about the Baha'i faith was the process that it used to arrive at decisions called consultation. In essence, consultation seeks to build consensus in a manner that unites various persons and constituencies instead of dividing them. It requires that information be gathered from the widest possible range of sources that may involve seeking the views of experts. During discussion, participants must make every effort to be frank and candid while maintaining courteous interest in the views of others. There is a belief that if a decision is wrong, it will become evident in its implementation, but only if everyone follows it without dissent. Now, it fascinated me because as compared to man's primitive forms of dispute resolution by clash of brute strength, in our current adversary system, which so bothered me in law school, which is a clash of vested interests, Consultation produces a clash of ideas, thoughts, feelings that hopefully will produce a spark of truth. Learning about consultation just after getting out of law school increased my concern with the adversary system that is still the process that our justice system uses today. Now, my concern with the adversary system is shared by many. The former Chief Justice Warren Burger commented in 1977, "The notion that ordinary people want black-robed judges, well-dressed lawyers, and fine courtrooms to resolve their disputes is incorrect. People with problems, like people with pain, want quick relief, and they want it as quickly and inexpensively as possible." And then in 1984, Chief Justice Burger told the American Bar Association that reliance on the adversary system as the principal means of resolving dispute is a mistake that must be corrected. For some disputes, this will be the only means, but for many claims, trials by adversarial contest must, in time, go the way of the ancient trial by battle and blood. Our system is too costly, too painful, too destructive, too inefficient for a truly civilized society. Judge Marvin Frankel, a former member of the United States Court of Appeals, in which I sit, but he was back east, wrote a book called Partisan Justice. It's a scathing indictment of the adversary system. He declares that the adversary system places too low a value on truth-telling and that there are other goods, but the greatest is winning. There are other evils, but scarcely worse than losing. And so when I became the first woman faculty member of the USC Law faculty, and I was a relatively new Bahai, I thought, what can I insert in my course on law reform? And I decided, well, mediation is the closest thing to consultation that I can think of. And so I added a section of the course on mediation. Mediation requires that people come together. They each tell to an impartial mediator or mediators what they feel their interests and needs are, what the problems are, and they then suggest what the solution should be. Often what parties originally complain about is not what they're really mad about. They have underlying needs and concerns that in mediation come out, that these concerns do not come out in court. Now, at a faculty meeting, I heard a professor at the end of the table saying, "What is Dorothy teaching? Mediation. That's not law." The reply I overheard was, "She's just trying to make everybody love everybody." Well, it's a source of great satisfaction to me that mediation is the hottest topic in the justice system today. Of all the forms of alternative dispute resolution, or as Janet Reno used to say, appropriate forms of dispute resolution, mediation is the one most used. Now let me tell you about an experience I had in India. In March of 1985, I arrived in New Delhi, India, to begin a visit sponsored by the U.S. Department of State to speak to judges, law professors, and university students about the American justice system. This was just a few months after the Union Carbide plant disaster, in which thousands of persons had been killed or injured in the worst industrial accident in history at a pesticide plant in Bhopal, India. When I arrived at the airport, I was met by a group of reporters who the week before had interviewed a lawyer, now deceased, from San Francisco. When asked by reporters why he had come, he replied, and spelling out the word, M-O-N-E-Y. He went on to explain that these victims had received serious injuries and were deserving of large amounts of damages that he could get for them in the United States. When the reporters asked me, "Judge, what would you do to resolve the cases of the Bhopal victims?" I replied that I would follow the procedure adopted by the European Commission on Human Rights. Note how closely allied it is to the Bahai concept of consultation. I would establish an international fact-finding commission to undertake a thorough investigation of the facts. Next, I would attempt a friendly settlement through mediation with all the parties concerned. If this failed, I would refer the case to the European Court on Human Rights. The U.S. State Department gave me several hundred clippings from Indian newspapers saying, in one way or another, "Mediation for Bhopal, says U.S. judge." Now, this demonstrated to me that people in India, as are most people, are crying for a faster, less painful, and better way to resolve their disputes. And further, lawyers and dispute resolution providers should have the role of constructive problem solvers and peacemakers rather than as zealous advocates. For instance, in the Bhopal incident, most potential litigants would have been satisfied with a $500 per year annuity together with payment for health care, rather than the millions of dollars promised by the San Francisco lawyer. If the parties had been given a voice with a nonpartisan intermediary, acceptable and accountable to all, the end result might have been a fairer, more just way to resolve the dispute with Union Carbide. That was 1985. Those disputes have yet to be settled. They are continuing on in the courts. Well, one of the most rewarding parts of my career has been working with the Western Justice Center, which is a center next door to my courthouse in Pasadena. By the way, you're always invited to visit my courthouse and the Western Justice Center. We won't promise not to involve you in volunteer work. But this center was created by judges, lawyers, and laypersons. Its goal is to promote peaceful resolution of conflict in the courts, in the community, and with children. When I came on the court, I asked our chief judge, "Why don't we have a mediator? Why would anybody want to mediate on appeal when they've won below?" He replied. I said, "But they might get a better solution through mediation." So he said, "Okay, I'll take one clerkship position and establish a court mediator." We now have 10, and they handled over 1,000 cases last year with an 85% success rate. Let me give an example of one kind of case that was resolved through mediation that gave a much better result than through the courts. Down in the Navajo Hopi area, the Navajos surround the Hopis. They have a much larger tribe, and the Hopi tribe is growing smaller. Well, a Hopi Indian went to Berkeley Law School, came home and surveyed the land, and said, "Navajos are living on our land," and he brought a lawsuit in Phoenix, Arizona. He had a treaty of 1872, which said this was Hopi land, and he won. The Navajos, speaking Navajo speak, said they don't need the land. We have a much larger tribe. We've been living there since 1902, and they bought carloads of guns, saying, we have the right to defend our property. It came up to our court, and our chief mediator, Dave Lombardi, had lived on the Navajo reservation during the summers. He conducted a mediation between the Navajos and the Hopis. And the elder Hopi, they would sit in a circle. Sometimes they would sit for an hour without speaking. The elder Navajo, the elder Hopi, would walk around the land pointing out by metes and bounds the land and to whom it belonged. After 6 weeks was a terribly long mediation. The Hopis agreed to let the Navajos stay on the land in return for signing a document acknowledging it was Hopi land. They exchanged $1, and David said, for both Indian tribes, light sprinkles came down out of the sky, which was a sign that this was a good thing. Well, there is now a Navajo Hopi housing authority in that area, and they're both benefiting from that housing authority. If it had come to my court, where we sit 3 judges at a time, we would have had to say, yep, that's Hopi land. And the Navajos would not have put their guns away, and I suspect there would not have been a peaceful resolution. Well, at the Western Justice Center, we're working with the police. Why? We have gangs, as there are in other communities, and the tendency is when something seems to be going on, the police would go in, put on the handcuffs, take the people in, call their parents, sometimes establish a record. We made friends with the police chief, Malekian, who is now working for President Obama, to teach police officers how to mediate disputes on the street. And when they see potential conflict, they come up, instead of saying, okay, line up, put out your hands, taking them in, they sit and say, what is this all about? They use the skills of a mediator to let each side listen to the other side and come to a solution. The mediation has done incredible work in terms of lowering the number of arrests, especially of young people. And in fact, the policeman who at first opposed this mediation system then came to the Western Justice and said, will you train our administrators on how to mediate disputes with the police? Thinking it works with children, let's have it work for us. In fact, we have a program for corporations and businesses which is called Work It Out at Work, to handle all sorts of conflicts among employees and their leaders in a given corporation. Well, we train children on how to mediate disputes. You all see the headlines on bullying, on violence in the schools, and the put downs and so forth. And so we have created model programs which we are now televising. We don't know we have the absolute solution, and the same mediation don't work in all schools, but deal with racism, deal with bullying, deal with the kinds of programs that teenagers have. And we've established a chat room communications under a program called Haven, where students in schools who are experiencing problems such as bullying and racism and the like can talk to each other about how they mediate these disputes and come to a conclusion. Why are these programs so important? I might add we've added music and we've added drama so children can act out some of these things. And in fact, we have a peer mediation invitational, not a competition, everybody gets a gold medal, to show each other how they mediate disputes. And I must say their acting skills are quite good and quite hysterical. But you know, I come from a family of teachers. And my Aunt Lou, who taught at Columbia, then taught out at Pacific Oaks School, told me about the 1960s in Boston, where she was. As all the officials were required to have rattans, or switches, for hitting children's wrists and behinds. At the same time, the public school curriculum called for the students to memorize a homily that included these words: "The good child obeys out of love. The wicked child obeys out of fear." Guess what happened to the child who didn't learn that homily? They got beaten with the switches. The child, in addition to the obvious contradiction that these and other children learned, was that by threatening violence, you can influence or force others to do what you want them to do. Today, these children are adults. The rattans are guns and nuclear bombs. And much of that generation learned that power and violence are a way to deal with differences and conflicts. Now, although some of our schools may have contributed to the ethic of violence, I'm pleased to tell you that there is the emergence of a new ethic in the schools, and that is peaceful resolution through mediation. And so at the Western Justice Center, we're creating models, we're training teachers, we're involving the dramatic arts, we have chat rooms. But I want to give you one example that has stayed in my mind for a couple of years. The reward for the children who are peer mediators is that they get to come to court at the end of the year. And I take them in the courtroom and say, today we're going to litigate a dispute. Do you know what that means? And they say, yes, suing. And I said, you got it. And then we're going to mediate. Well, I had a group of fourth graders, and the problem that was given to them, a child got an F. The child thought she deserved at least a C. The child sues the teacher. And this is not so unusual, let me tell you. So we had a fourth grade lawyer for the child, a fourth grade lawyer for the teacher, and then we have a big courtroom, and the rest of the students got to sit up as judges. Little Herbie, fourth grader, got up to the podium, and we put a little stand so they see their heads. "May it please the court," he said. "My client got an F because the teacher is a racist." First words out of his mouth. Most of these children come from underprivileged schools, minority schools, and we sort of target those schools. Well, I won't tell you all of his arguments, but then George, the lawyer for the teacher, got up and said, "May it please the court. My client cannot teach a class of 28 if kids come to school late, they don't do their homework, and they fall asleep in class." Little Herbie got up and said, "May it please the court. My client falls asleep in class because she comes to school without breakfast." They're all talking from their own personal experience. Well, the judges voted, and guess who won? Herbie won, George lost. We had a winner and we had a loser, and then they mediated. As they had been taught to do, Herbie came in and said, "Hello, my name is Herbie. George, I'd like you to meet my client, Laura." And Herbie said, "Well, I'd like you to meet my client, Mrs. Brown." And Herbie said, "Laura, you tell Mrs. Brown how you feel about that F. I hate school. My parents hate me. I don't want to go to school anymore." And then George said, Mrs. Brown, will you tell Laura how you feel? These are fourth graders. Well, Laura, I love you. I really do love you, but I can't teach a class of 28 if children come late and don't do their homework and fall asleep. Those fourth graders decided the teacher should stay after school and tutor Laura. She shouldn't be given a grade she didn't earn. But you know what? That would show she wasn't a racist. Someone ought to write the PTA and say, kids are coming to school without breakfast. And at the very end, the reason I remember this group, they hugged each other. This was all make-believe. We're fourth graders, you give us a problem, we can solve the problem. It's this kind of collaborative, cooperative, courteous, kind process that enabled these kids to figure out how to solve their problems. I love the letter from another fourth grader in that class. Dear Judge Nelson, thank you so much for helping us learn more about mediation. But I want to ask you a question. Why don't you teach mediation to the adults so that we will not have war anymore? That child got the essence of what this is all about, whether it's mediation, whether it's consultation, whether it's crime, whether it's poverty, whether it's the environment, whether it's racism or discrimination. We have to find ways to peacefully resolve disputes. And actually, if we want to have war no more, all we have to do is get the nations of the world to come together to peacefully resolve the conflicts. It is clear that when children at this age participate, it is something that will follow them through. In fact, we have graduate students at the Claremont Colleges following Herbie through the 5th, 6th, 7th grade and so forth, seeing if these social skills affect how these children succeed in school, not just academically, but socially as well. In fact, it's sort of interesting, when the children first come in, we always feed them. And at the very end, we say, and what do you think is better, litigation or mediation? And they all yell, mediation. And I say, good, then you get pizza, because one of my former students owned California Pizza. At any rate, these children feel that justice has been done. And oftentimes as I'm feeding them, I say, give me an example of your best mediation. 9 times out of 10, the children will raise their hands. My parents are always fighting. I say to them, why don't you mediate your disputes? And they say, what's that? What's that? You have to listen to each other. You can't interrupt each other. You must show courtesy towards each other and the like. And it shows to me that they're transferring these skills into their own lives. But even if we find the most peaceful resolution of conflicts, the most perfect process will not lead to a just system unless certain social and economic ills are addressed. These include the abolition of racism and prejudice, the recognition of the equality of women and men, the need for universal education, the inordinate extremes of poverty and wealth must be abolished. And as the prophet founder of the Bahai faith said, we need to recognize that this earth is but one country, and we should regard humanity as a single individual, and know of a certainty that if pain or injury afflicts any member of that body, it must result in suffering for all. Only then will justice be realized. Thank you for your kind attention.
Judge Nelson, you have inspired us over and over and over, those of us who have known you. I was looking over the materials that are available on the internet, and a former colleague of yours who worked for you and I believe is now a vice president and chief counsel as one of the leading provider of risk management, had this statement that I wanted to share with our audience. He wrote in his blog, "When I was clerking for the Honorable Dorothy W. Nelson of the United States Court of Appeals for the Ninth Circuit, my judge was and remains a delight. She was a warm, engaging person who treated everyone as an equal. She was living proof that you don't have to give up on human kindness just because you've become powerful. She taught by example many lessons about work-life balance and the meaning of humanity." Well, you touched our heart. Every time you speak, you infuse love in the room. I feel it in the air, and it touched my heart. Thank you very much. Really, really grateful to you. I'm sure there are some of our friends who may have some burning questions to ask you. I'm wondering whether you would be kind and you would accept taking some questions.
Yes.
Okay.
You didn't tell me. I would have asked. The best part of any program are the questions, so I invite anyone to make a question or a comment. Yes, would you please rise and...
Would you consider the United Nations a success or failure? Would you consider the United Nations?
It's not on.
Hello?
Yes, thank you.
Sorry. Would you consider the United Nations a success or a failure? And if you consider it a failure, could you tell us your ideas on how to make it better?
The question, as I heard it, do I consider United Nations a success or failure? If I think it's a failure, what steps should be taken? I think the United Nations is a very important body, a next step in the process toward obtaining world peace. But, of course, it has many issues and many problems. I was a delegate to the United Nations Women's Conference in Mexico City in 1975, and then again in China in 1995. And I found the work of the non-governmental organizations simply amazing. I remember one particular one, it dealt with a movie actress who was trying to help get rid of family abuse in Africa. And she devised a video, had it mounted on elephants to go into villages where men were beating their wives and abusing their wives. That video, taken into the villages by an elephant, had more effect than any pamphlet, any lecture, any urging by people coming into the villages to tell them they shouldn't beat their wives. Well, when people are creative like that and creating solutions to the world's problems, the non-governmental health organizations getting rid of river blindness, doing all sorts of wonderful things. But as we all know, the United Nations cannot solve the problems of the world. It has to begin at a local level and move from down to up. And if we can resolve our conflicts, Santa Monica has a wonderful record in its human relations work. It will surface to the top. But you say, why doesn't the United Nations solve the problem in Syria? Why doesn't the United Nations? It's the people of the world that have to solve those problems. So I have great admiration for particularly the work of the non-governmental organizations. The political organizations are going to have to evolve into a process where we, the peoples of the world, and our leaders listen to other leaders of the world. If the world is one small world, what, as I tried to say, affects one small part of the world affects us all. Until we gain that mindset, we cannot expect any organization to resolve anything. And so my solution would be to the parts that are failing, they need to learn how to resolve conflict peacefully instead of imposing power and force, that they sit down in a loving, and I mean that, courteous, kind awareness that we are all brothers and sisters in this world. Sorry to be so long. We have another question? Yes, please.
Thank you so much for your comments. When you're teaching mediation, and you see that one of the parties has an information gap relative to the other party, knows less, let's say, than the other party about what their rights might be, how do you, as a neutral mediator, deal with that injustice, so to speak?
It's a very good question. You know, you could have good judges and bad judges, good mediators and bad mediators. A good mediator will encourage both sides. When you talk about rights, mediation actually, on the one hand, is concerned with rights, but is more concerned with the needs and interests of the parties. I don't mediate, I judge. I will send cases to mediation. I have, in the past, mediated disputes, but I would then encourage the parties to talk more about their interests and their needs rather than their rights. Mediation is not legally binding. And in our court, our mediators do, after they spend time, when the parties agree, have them write out their agreement and sign it, and that's enforceable. But if you don't like what's happening in mediation, and you feel that you're not getting anywhere and this party might be better served through another means, I would stop the mediation. But if I'm the mediator, I would focus less on the legal rights, but more on the needs and the interests of the parties, that they will feel a fair and just solution has been reached that will be satisfactory. But it's a very good question that can be a problem when you have someone coming in, particularly in family law cases. But, you know, let me just tell you, I have a huge caseload. We sit and hear 6 cases a day. They only get 10 to 15 minutes aside, 5 days, so you would hear 30 cases in a week. Of those 30 cases, I would say 25 could be resolved by mediation. They deal with employment discrimination. They deal with, well, discrimination of all kinds. They deal with workplace problems with administrators. They deal with various kinds of problems, like the Navajo Hopi problem. That could be, if people would sit down and figure out what their interests and needs are, you know, who needs to go to court, who needs to go through all this misery. Because mediation can take place very, very quickly. In our court, an appeal, it may take you 4 years to get your appeal heard. It's not just having it heard, it's the emotional worry about being in court and being unsettled for that period of time, plus not having input. I'll never forget my husband, who when he first went on the court, was in small claims, and a woman claimed that her dress had been ruined by the cleaner. She failed to pay the cleaner. The cleaner sued her for what she said was a $500 dress. Well, she decided to go to small claims because she didn't want to hire a lawyer. And my husband heard her testimony. Heard the cleaner's testimony and then heard her testimony. And he decided that she had no proof, she had nothing there at all, and held for the cleaner and said, "You may go home now." And the cleaner said, Your Honor, I want you to hear what I've been through, what this woman made me do, give up a day of work. He said, "Sir, you won. Go home. But I want someone to listen to what I've been through because of this terrible woman." Well, people want to be heard. And mediators, you should not be, I'm going to get in trouble for this, but most judges are not good mediators. The reason is they're used to telling people, this is what you ought to do. The law says you must do this. It's very hard. And there are some notable exceptions, I might say. One of them is in this room, where people have the patience to listen to what the parties are saying. So, I guess the moral of the story is, try and have the best mediator possible. But the saving grace is that the mediation can just be over. If the mediator feels that justice is not going to be done, we'll say, I think this ought to be worked out in some other way. Yes, please. I'm sorry, I don't know all your names. I should remember your names, but I don't.
My name is Gary. And obviously a lot of disputes and that could end up in court or mediation are due to misunderstandings. And I remember your comment with regard to the kids, the fourth graders and Herbie, and how there was a difference in a way of looking at things from the kids to the teacher. And I'm interested in the issue of global education, creating global citizens out of our youth. And I'm wondering if by having better understanding from kindergarten up between kids, it would resolve a lot of issues. Things would not end up in the courts and in mediation. Do you think that by focusing on kids at an early age of understanding each other, that would help in that?
That's the answer. And we talk about the United Nations, is the United Nations successful in working out the peace of the world? You start with the kindergartners and all the way up, and you train them about listening. Listening is a big problem. Listening to each other and coming up with solutions on their own, often better than solutions, far better than the court could ever give. I think that is one of the paths toward world peace, as a matter of fact, which, as I say, if we decided that we wanted to have it, we can have it, but it's going to start in the community. So I know you work in the community, and I wish you well. I think they're exhausted here.
Judge Nelson, let's
Mr.
try
Chair?
to take the last question, perhaps. And I think this gentleman.
Thank you. As we all know, and you know, that the purpose of religion is to bring love and unity. And unfortunately, the religions of the world today are doing the opposite and causing disunity and dissension among people. Is there any organization or any way that you know that one can do mediation between the religions of the world?
Oh, the question, are there organizations that can train people to do this? What was the question? Did I get the question correct?
Yes, you did. Yes, you did.
Oh, yes. Western Justice Center, when we put something on the internet And this is why the internet is so wonderful. We can reach thousands of people. And one of the new things that we're doing is to provide feedback to us about people who are using various forms of mediation. There are various ways to mediate disputes. It is traveling fast. I was invited to China, by the way. They've been mediating disputes for thousands of years. I thought, oh boy, I'm really going to get educated. But what I found out in China, they have living units. And in the living units, they elect their mediators. And most of their mediators are retired women workers who then oversee the community. And they are more like retired judges, with notable exceptions. This is what you ought to do, rather than saying, and what do you think would be fair? And what do you think would be fair? And having them come up with the solutions. Of course, when they come up with the solutions, they're much more likely to follow them, as opposed to having them impose. In fact, there is a student at USC who is doing a paper on the number of people who never collect on judgments that they get in a court. It's one thing to win. It's another thing to collect. In mediation, where people come up with their own solutions, they have devised the solutions, and they're much more likely, in fact, almost without exception, to follow those solutions. But that was a welcome question. And you go on the internet, there are literally hundreds and hundreds of organizations. When I first started in the law school, it was unacceptable. It is now taught in what we call ADR, appropriate forms of dispute resolution, in every major law school in the nations. And there were very few mediators when I first came on the court. And when we got our first court mediators, I got hate letters from lawyers. What are you doing? Taking our business away from us. I remember particularly several from Seattle. Now I get love letters. Dear Judge Nelson, I have to honestly admit, I am leading for myself a much more peaceful life than I ever thought was possible as a lawyer. And you know what? I haven't lost clients. My clients are so happy to have their problems resolved quickly. I have more clients, I have happier clients, and I have a happier wife because I come home not in an adversarial mood. And so anyway, there are many, many benefits above and beyond those I have described. Well, thank you. You've been very kind.